Well, we'll go ahead and get started. We are expecting a few more today, and we'll just let everybody come in. I'm Shannon McCracken, CEO of the Nonprofit Alliance. Our members are nonprofit organizations and firms that work with nonprofit organizations. Together, we promote, protect, and strengthen the nonprofit sector. Today's program, your latest need to know COVID-19 protocols and best practices, is the first in our Workplace and Workforce 2022 series. If you haven't already, please go ahead and introduce yourself in chat, put in your name, your organization, your role, and where you're located. That'll just help set the stage for others who join us late to be able to do the same, and we'll know who's here in the room with us. We certainly invite you to turn on your cameras and come off mute as you're comfortable doing so. We're pleased to have with us today Jeff Tenenbaum. He is the managing partner of Tenenbaum Law Group here in DC. Jeff is a highly sought after attorney working on the business and governance issues that affect nonprofit organizations and associations. And I think a large portion of Jeff's time in the past 2 years has been spent on navigating the pandemic, what that looks like for organizations and associations, everything from in-person events to reopening offices to managing current and future staff hires and all of the shifting sands and the starts and restarts that happen around us. Certainly, we know that some of that, some of the legalities and the considerations are different based on size of organization, perhaps type of organization, and locality. So Jeff will help guide us on some of the need to knows on that today. We're going to start with opening up to Jeff, letting him just share some of the most current information of what we need to be considering. And we invite you at any time, if you have immediate clarifying questions or something to add or ask to what Jeff's sharing. He has said he's very comfortable with you just jumping right into that and being able to do that informally on the fly. If you have any questions that you would like me to pose for you, either because you aren't able to come off mute at that moment, or you would like to keep that question more anonymous, you can send that to me just directly in chat and I can keep an eye on that and do that for you. We are recording this session so that we can make Jeff's expertise available to others. Again, if there's anything that you do share today or comments you make that you prefer not to have available in the recording afterwards, you can let us know and we'll cut that out. Okay, so Jeff, I'm going to hand things over to you. Thanks so much for being here and take us away.
Thank you, Shannon, and good afternoon, everyone, or good morning to Melinda, who was a client of mine out in Southern California, enjoying a little better weather than we are here in the DC and Maryland, Virginia area, where I think most of the rest of us are. I'm in downtown DC. Welcome to today's program. So the issues that I'm going to be talking about here today are issues that I have been, and my colleagues and I in our firm have been advising our clients on for weeks and months now. As you all know, the pandemic has been with us for almost 2 years. For some nonprofit organizations, in fact, many in the DC area where I'm located, many workforces are still completely virtual and remote. But many, even in the DC area, have started to come back into the office in some sort of a hybrid form. Some people in the office, some people out, everyone coming in certain times of the month for different meetings and other things like that. Others are still completely remote. But everyone seems to be at least thinking about and planning for, except those that are kind of have decided to go completely virtual. Most other employers, nonprofit employers, are thinking about kind of the return to an in-person office environment, at least for some people, at least for part of the time. And that, of course, raises all sorts of questions that arise in connection with COVID. Questions about remote work policies for staff and what can you do legally and what can cross the line and create legal problems for you as an employer. Can you mandate vaccination for those coming into the office? Can you mandate testing? What sort of exceptions do you have to legally make for people who, for different reasons, cannot be vaccinated or are opposed to being vaccinated? What sort of accommodations do you need to make in those situations? all of these issues up, and of course, it's not just coming into the office; it's travel as well, and a lot of that has already started to recur because nonprofits across the country are starting to and already have some never stop, but many are starting to have in-person conferences and meetings and events. Shannon and I were just talking about an event that they're going to be having in coming up in Milwaukee very shortly. This is becoming the norm, so it of course raises questions for staff in connection with travel, and a lot of those same questions about vaccination requirements and testing requirements and masking and social distancing requirements and all of the rest. And you still have a number of employees who are reluctant to travel for work because of COVID fears. How do you deal with that? What requests do you have to honor? What can you deny? What sort of policies can you put in place? Mandating that staff come into the office, that they travel, et cetera, when some staff are very concerned about that. These are the issues, these are the questions that I get asked about almost every day, and that we've been advising our clients on, and these are some of the issues we're going to talk about here today. In addition, to the extent that you guys have questions about how some of these same issues apply in the meeting and conference and event setting, because we get those just as much as we get workplace related questions, vaccine requirements, mandates for attendees at your meetings and events. What sort of exceptions do you have to make there? Do you have to offer an alternative testing requirement for those who don't want to be vaccinated? Those sorts of questions, to the extent you want me to speak to those in the meeting and event side of the house, I'd be happy to do that as well. I know we have a small group here, but I really want to encourage you to ask as many questions as you can and to ask questions throughout. And that includes you too, Shannon and Abby. I want to make this as interactive as possible. And to the extent that you guys have your own examples or experiences or those that you've heard from other nonprofit executives with whom you work, please share those as well. One of the nice things that I have from my vantage point is the opportunity to work with hundreds and hundreds of different nonprofits every year and be able to see all of the different vantage points and perspectives and best practices and what sort of practices tend to get nonprofit employers into trouble, what tend to work well. And I will certainly try to do my best to impart some of that to you today. And like Shannon said, if you don't want to pose questions directly, by coming off mute, just pose them to Shannon in the chat, and she'll pose those to me. So let me start out by kind of giving you a few basic kind of legal principles that apply here, so that you can get the overall context. First off, the legal construct that governs these issues is both a federal, state, and local construct. And there are laws and rules and guidance that apply at all three levels. At the federal level, the rules, the guidance are largely advisory in nature and not binding. As many of you probably heard, there was an attempt by the Biden administration to have OSHA, the Occupational Safety and Health Administration, impose a vaccine mandate on large employers, those over 100 employees, to require them to either mandate vaccines or have a testing alternative, mandatory testing alternative. That rule was effectively shot down by the U.S. Supreme Court and will not be going into effect. So there is no vaccine or testing mandate for large employers at the federal level as the administration had intended. At OSHA and throughout the pandemic, OSHA has had a lot of very helpful guidance on their website that they put out about kind of COVID and the workforce. Again, it's all advisory in nature, but it's very helpful guidance. And it effectively has some legal implications because something called tort liability. All attorneys take torts class in first year law school. And what it means is, in this context, the liability of an employer, if say an employee were to contract COVID at the workplace or in connection with work travel and were to make a claim that the employer was negligent in how it conducted its operations, and that's what caused them to contract the virus and any other implications that, adverse implications that befell the employee. One of the things that you would look to is was the employer negligent in how it carried out its operations, its policies, its practices, procedures, et cetera? And in determining what the standard of care is to see whether or not the employer was negligent, one of the first places you would look is to OSHA's guidance. And did the employer follow OSHA's guidance in this regard? And so while it's not technically binding, it can be brought into play and is brought into play all the time in connection with tort suits. Now, granted, in the employment setting, you probably all heard of workers' compensation. Most claims by employees in this regard for personal injury in connection with the workplace have to go through the workers' comp system, which significantly limits the ability of employees to recover damages and helps to kind of mitigate the risk of the employer. But still, it's all still relevant here. So you first look to OSHA's guidance and see whatever you can do. They have guidance on everything from masking and social distancing to sanitation and ventilation and everything else. Spacing out of cubicles and dividers between cubicles and having as many private offices as possible and trying to stagger people so you don't have as many people in the workplace at one time. All of that sort of guidance. You should take a look at OSHA's guidance on its website. It can be very instructive. Then you look to state and local laws. By local, I mean city and county. And many states and cities and counties do have binding either legislation or executive orders from a governor or mayor or county executive that do regulate these issues in the workplace. For instance, in some states and cities and counties, not DC or Maryland, Virginia, where I know the majority of you are located, but in certain other states and cities and counties around the country, it is illegal for an employer to impose a vaccine mandate on its employees. And so you obviously need to be well aware of what prevailing binding requirements are in place at the state, city, and county level. Obviously very important. Beyond that, another really important legal principle to keep in mind here is objectivity and consistency. What you do has to be done on an objective and consistent basis. Otherwise, you risk legal claims against you for things like discrimination by treating similarly situated people differently. Does that mean everyone has to always be treated the same? No, it doesn't. But similarly situated people have to be treated the same. Otherwise, you run the risk of discrimination and other similar claims being brought against your organization. So where do you start in being objective and consistent? Well, you start with your written policies. Really, really important. Probably almost every day, my colleagues and I are reviewing written policies in the workplace for conferences and meetings and events. And other things like that. And certainly in the workplace, we've reviewed and edited and written plenty of COVID-related policies on all of the issues I talked about earlier, from vaccine mandates to exceptions, to testing, to masking, to social distancing, to travel, to everything else. Some of them that we review are really kind of well thought through, really well written. Some are not so well written and very confusing. Some are inconsistent. You don't want to have any of that. Confusing and consistent. You want to be clear, and you want it to be able to be applied on a consistent and objective basis. That doesn't necessarily mean that all staff have to be treated the same way. For instance, and we've been dealing with these issues about objectivity and consistency well before COVID, for instance, when it comes to remote work policies. Because we've always had the issue where if you allow some people to remote work and others not to, and someone says, well, the reason you're not letting me remote work is because of, name your protected characteristic, race, gender, sex, age, etc. You've always run that risk, which is generally speaking why you want to try to be as consistent as possible with your remote work policies. But it's always been, for instance, permissible to say that some jobs lend themselves to remote work and some jobs don't. So say for a larger employer that has, someone whose main job is to deliver the mail every day in person in the office, or someone whose job is to work behind the reception desk and answer telephones and greet people that come into the office, these jobs don't lend themselves to remote work. Whereas someone who's, for instance, in the finance department or a meeting planner might well lend themselves to remote work, except, for instance, when the meeting planner needs to go and do site visits and be on site for conferences and meetings and events and things like that. And so you can have policies that treat people differently as long as it's done on an objective and consistent basis. It's also permissible, for instance, to say, everyone who was an employee of ours, prior to the pandemic or prior to now, we're going to kind of freeze your remote work experiences in place. And for instance, if you're remote working now, we're going to continue to allow you to, except, however, and Shannon gave me this good example earlier from someone else she was talking to, except, for instance, twice a year or once a month or whatever it is, you're going to have to come into our headquarters office for meetings. And you're going to have to be on site at our annual conference. But other than that, you can remote work. Whereas all new employees that get hired after this are not going to be eligible for remote work. I'm not saying you need or want to make those distinctions, but as long as you have some kind of legitimate, objective, non-discriminatory basis for drawing those dividing lines, that's okay. But you need to treat everyone in those different groups of current or prospective employees the same way. You need to treat them the same way. If you're going to have a vaccination requirement, for employees that are coming into the office. Like, for instance, I was reviewing one policy the other day that said the organization, the nonprofit employer, had a vaccine mandate, but the vaccine mandate did not apply to employees who are solely remote and who don't have to travel for work. Because why would you need to impose a vaccine mandate if no one's pretty much ever leaving their home for work-related issues? But for those who do have to travel for work, or who do have to come into the headquarters office once in a while, then they did have a vaccine mandate. I think in that case, they had a testing alternative. They call it test and mask alternative, which is kind of very common, that if you're not fully vaccinated, you have to show within 48 hours proof of a negative COVID test and wear a mask at all times unless you're in a private office in the workplace and when you're on work travel. And you can even require a PCR test, which is more accurate than the antigen kind of at-home COVID tests. One of the issues we've seen, by the way, with the at-home tests is that if any of you have taken them, probably many of you have, unless someone's doing it in front of you, which would be unusual and awkward, there's no way to really know that it's that person's negative test because there's no identifier on it like there is with a PCR test that shows, whose test results they are. So my point is it's very conducive to fraudulent activity if someone wanted to fake a negative COVID test, just something to keep in mind. But, it's up to you. Even in most states and cities and counties, you can require the employees to pay for the cost of those tests. There are some jurisdictions like in California where it's arguable that the employer has an obligation to pay for those tests. And that's always something you've had to take note of is the employment laws that govern the organization are driven by where the employee is principally located. So, and this has been a big issue because now with so many nonprofit employers having remote workers, like Abby for the Nonprofit Alliance works out of her home in Brooklyn. She's now governed by, if it was just temporary for a couple of months, like everyone thought at the beginning of the pandemic, that would be one thing. But once it's more permanent or for the indefinite future, she is now governed by the employment laws of the state of New York, not the employment laws of the District of Columbia, where the Nonprofit Alliance is headquartered. That's very important to understand because state employment laws vary significantly from state to state. Certain states, like in DC, has a lot more protected characteristics than even in, say, neighboring Virginia. California is probably arguably the most employee-friendly state in the country. And for that reason, I have some clients who have a remote work policy that says you can remote work from anywhere except California, because we don't want to be governed by those states' employment laws. That is acceptable, legally acceptable to do, and frankly, not uncommon. In California, for instance, for non-exempt employees, I'm talking about exemption for purposes of the Fair Labor Standards Act, exempt versus non-exempt for overtime requirements. In California, overtime is calculated on a daily basis. So if you're a non-exempt employee in California and you work over 8 hours in a given workday, you are obligated to be paid time and a half for overtime for every hour or every part of an hour over 8 hours in that day. Whereas at the federal level and for most other states, it's dealt with on a weekly basis. It's 40 hours in a week. So if you have an employee who works, 12 hours one day because they're, staffing your conference or something, and they do that for 3 days in a row, you can actually require them to take the rest of the week off or a certain number of hours off so that they don't go over the 40 hours in a given week and have to be paid time and a half for overtime. In California, you can't do that. So my point is, you have to be aware of these state laws. For most of our clients, we're helping them revise their employee handbooks accordingly, because the employee handbook has to be tailored to all of the different state laws. In a lot of cases, it requires you to come up with kind of a lowest common denominator, because you often don't want to have different policies and rules on everything from paid leave and accrued leave and other things like that. So you end up going with the least common denominator for all the various states that apply. It also is requiring employers to register in these different states for different purposes. And unfortunately, it's never just one simple registration. You're registering for unemployment, insurance, compensation. Sometimes you're registering as a qualifying you to do business as a foreign corporation, because you have an employee in that state. You arguably are obligated to do that in every state where you have a remote employee. And there are other kind of business and tax and employment and other regulatory registrations and filings that are required in different states. It's no question, it's a pain in the neck. It can be costly. It can be burdensome. But that's the price that we pay for having remote workers in different states. And you can't just put your head in the sand and just say, well, it's only temporary, because it's not temporary anymore. And I'm sure, like a lot of your employers, almost every employer I know, I don't frankly, we have clients all across the country. It definitely varies by geography. We have some in the Midwest and elsewhere that they're back in the office full time, and they have been for quite a while. And that's the expectation, and that's what the CEO wants. In many others, particularly on the two coasts, we're seeing it's kind of hard to find a nonprofit employer that's not considering some form of remote work on a permanent basis, and kind of building that into their policies and trying to figure out what it's going to be. Do you have to be in the office 3 days a week and you can remote work 2 days, or the other way around? Or you can, if your job lends itself to it, you can remote work all the time. However, whenever we have all staff meeting, you have to be in the office and you have to attend our annual conference, things like that. Whatever you do, like I said earlier, just make sure you do it on an objective and consistent and non-discriminatory basis, and make sure it's well written and documented in a policy.
Jeff, I have a couple questions. Can I jump in with you on this topic?
Absolutely, because I needed
give you a coffee break too. So you indicated that that we can set employers can set a policy that says that current employees, if they want to relocate, can relocate anywhere except, for example, certain states. How much can you limit that? So can you limit it to, say, only the states where you have people living right now, so you're not needing to go through those extra steps of registering with a new state, particularly relevant for smaller organizations? And part two of that is, can you similarly limit when you're posting a position, for example, to say we are open to remote work, but you have to reside in one of these states, again, just to avoid having to go through the whole registration and compliance process for potentially one staff member?
Yes, you could. You could do both. It seems unusual. It's not. I haven't seen that as a common practice, at least yet. I've seen the no California rule. But yes, you could do that. And one of the main reasons you can do it is that you're not discriminating against people on the basis of a protected characteristic. Where you reside, geography is not a protected characteristic, at least that I've ever seen in any, certainly not under federal law. And I've never seen it under any state law either. And so, yes, you could do that. And there's understandable reasons for doing so. Absolutely.
Okay. And another question, and while we're paused here, we can let others jump in too if you have questions. But on the topic of being objective and consistent across, whether you're talking about remote employees or in-office employees, can you offer different benefits? So for one example that I heard this week was an organization considering offering additional paid time off days to people who were working in the office, were coming back to the office. The reason being for them was there's either real or perceived more flexibility for people who are working remotely to, run an errand at lunch, or pick up their child at school, or have an afternoon dentist appointment. And it's harder for people who are visible in the office to take that time and not submit sick leave or something. So is that a way to sort of even out that perceived fairness issue for one staff member versus another?
It's a great question. I hadn't heard of that. I had not heard of that scenario before, but I think you could. Again, as long as there's an objective, defensible rationale for why you're doing that, and you just articulated it, and as long as you apply it consistently, to everyone who's in the office and everyone who's not in the office, you're doing it the same for both. Yeah, I don't think that's a problem. In fact, one of the big complaints I've heard from employers constantly during the pandemic is that kind of this, and I don't think it's a fair criticism of all remote workers for sure, but it's been an issue of kind of, is PTO meaningless these days? Now, look, we have, some of us work like Shannon and I all the time, 24/7. Most normal people who have a life don't want to do that, but they are online, and they're generally available all day long during the workday, and then they disconnect at night. Shannon and I could take some lessons from you guys, but some people, what we're finding, what I've heard from a lot of employers is that, employees have a certain amount of accrued PTO, and in many employers, you get paid out for that when you leave the organization for the value of that. Yet a lot of employees are not taking PTO when they're remote working because the employer doesn't really know when they're fully working. There are tools, and I've seen they're not really common in the nonprofit space, but in the for-profit space, I've heard about tools that employers are putting on the employees' computers and whatnot that can actually tell when you're actively working, not just when you're logged on, but when you're actively typing and things like that on your computer, or using your camera and Zoom and microphone and all that sort of good stuff. So they can really track when employees are working. But it's a real issue and a real problem, and it would kind of help to explain and kind of justify that sort of policy that you just proposed, which I think is not a bad one, especially if you want to create incentives for employees to be back in the office. Look, every employer is different. I have one client, very large organization in DC, where they want, and the CEO really wants most or all of their staff to be in the office, at least a certain number of days a week, because the CEO feels like they are missing out on a lot of the connectivity and exchange of ideas and teamwork and other things that comes from being in the office. And that's a priority for that CEO. And they're putting in place policies. They keep trying to put in place, like everyone else, it keeps getting pushed back. But putting in place policies to do that, I think, everyone in the DC area is going to be required to come in, I think, a minimum of 3 days a week, but they can pick which days they want to do it, although they can't take off on Fridays or something like that. Everyone has different policies, or they're contemplating different policies in that regard. Whereas others are like, look, this has worked great for us for the last 2 years, with remote work, and we don't have a problem with it. And our employees seem happier and whatnot. So a lot of it's often driven, it's certainly driven by the culture of the organization, but it's often from the top down, and it kind of reflects a lot of times the perspective of the CEO. Whatever you do, whatever policies you have, just make sure they're objective, you enforce them on a consistent basis, and they're not discriminatory in any way. Shannon, were there any other questions?
I don't have any right now. Any others from the group?
Shannon, if it's okay, it's Melissa. And again, I'm sorry I'm not on video. This is obviously pretty unique to ASYMCA. We're in 9 states. Obviously we're trying to work towards that lowest common denominator because we've got locations that are on military bases as well. So there's a bunch of nuances for us. But another nuance that's coming is we are working towards being more present in the federal contractor space. So I was interested in, the stop and go. Do we pause and see what this latest round of pause on the federal contractor mandate? What are your thoughts there? I'm not going to hold you to it, obviously, but just interested in what.
But I'm not sure what you're getting at. There's a federal mandate for those that receive federal funds through Medicare and Medicaid for healthcare workers, vaccine mandate. The mandate for large employers was effectively struck down by the U.S. Supreme Court. Are you referring to either one of those or something else?
The federal contractor where they were trying to flow down to those that are considered federal contractors. We are actually bidding on a pretty large federal contract.
And are you referring to a vaccine mandate or something else?
Yes, vaccine mandate.
Okay. And so what, I mean, if you, anytime you accept federal funds, grant, cooperative agreement, or contract, it's just like the same reason that the U.S. Supreme Court said it's okay for the federal government to require vaccine mandates for healthcare workers, healthcare institutions that receive federal funds. Anytime you receive federal funds through a grant, cooperative agreement, or contract, the federal government has the ability to kind of hook in all sorts of requirements for you as a condition of receiving those, and even as a subrecipient, because they can require the direct recipients, the prime recipients, to have subrecipients like subcontractors be bound by those requirements as well. And there's always been a whole host of requirements, everything from affirmative action requirements to anti-discrimination rules, having certain policies in place, other things like that, that the federal government can mandate. So, I mean, that's just one of the prices you pay for receiving federal funds. And you have to be obligated to comply with all of those requirements, including any requirements that might exist in the vaccine front. So I'm not sure what your question is beyond that. I mean, it's pretty black and white if you want to receive those funds.
Right. Just I was curious as to what you think the ultimate result might be. I think there's a stay in place right now on the federal contractor.
Yeah, your guess is as good as mine. Although I think I mean, obviously I follow this closely. The U.S. Supreme Court's bifurcated decision, and again, their decision wasn't a ruling on the merits; it was a ruling on whether these rules should be paused while the lower courts consider the cases. But that's why I keep saying effectively, because the Supreme Court clearly tipped their hand as to where they will ultimately rule on the merits, and that they put a stay, which means kind of an injunction. They stopped the vaccine mandate for large employers from taking effect, but they did not stop the vaccine mandate for those that receive healthcare funds. If you kind of draw that out, if those other issues get to the U.S. Supreme Court, I would think that there's a good chance that they would rule the same way. On that basis, because the ruling for large employers is basically that OSHA didn't have the legal authority to issue that sort of mandate. Whereas if you're receiving federal funds, I think that's a whole different construct.
Got it. Thank you.
Sure. Let's talk about vaccine mandates for a second, because in the nonprofit world, especially we're seeing it more on the coast than in some other places. The color of the state, blue, red, certainly factors into this, no question about it. And like I said, there are some states and cities and counties where it's actually illegal for an employer to impose a vaccine mandate. There's even some states, including two big ones. And by the way, when I say coast, I'm not referring to Florida, because Florida, Texas, Alabama, North Dakota, and Iowa, and possibly some others as well. The last time we checked, it was those 5, but there's likely others as well at this point. Make it illegal for businesses to require proof of vaccination as a precondition of entering the business. And that includes hotels, convention centers, restaurants, retail stores, et cetera. And Texas and Florida being 2 of the biggest states, and states where a lot of nonprofit organizations hold conferences and meetings and events, by the way. It doesn't necessarily mean that a nonprofit that's holding a conference in Florida or Texas is not able to impose a vaccine requirement on attendees. But what it means is that the hotel or convention center itself is not able to do so. But so you obviously first have to look to the state and city and county laws to see and rules to see what applies. But assuming there is no ban on a vaccine mandate, many nonprofit employers are imposing vaccine mandates on their staff. And there's different ways to do it. And there's no right or wrong. We don't counsel clients on what they should do. We just counsel clients on, if you want to do X, Y, Z, here's a way to do it lawfully. And this is consistent with everything I said earlier about having good written policies, being clear, consistent, objective, et cetera. So a couple of the leading constructs that we're seeing. One is that full vaccination period, usually as defined by the CDC. Well, I've had some clients recently ask me, even though the CDC still requires full vaccination as the initial 2 Pfizer shots or Moderna or the single Johnson & Johnson shot, at some point, most expect the CDC to update the definition of fully vaccinated to include the booster. That hasn't happened yet. But if you, as an employer, want to define full vaccination as requiring the booster shot, you can certainly do so. You're certainly able to do so. So one construct is vaccine only. Another construct is vaccine or test and mask, meaning you have to show, say, within 48 or 72 hours, proof of a negative COVID test. You can define that as PCR if you want to, or antigen home test. And you have to wear a mask at all time when you're in the office or on work travel. So some are having that construct, but some are saying, no, we want, and our employees are demanding, they want to feel safer in the office. You know, we have a highly vaccinated workforce, so we don't want to have an exception for negative COVID test and mask, and we want to have everyone have to be vaccinated. You can do that. However, you have to make, it's not exceptions. Everyone uses the term exception, but it's really a misnomer because they're really not exceptions. What they are is reasonable accommodations. So there are 2 federal laws that come into play here in the workplace. One is the Americans with Disabilities Act, and one is Title VII of the Federal Civil Rights Act. Under the Americans with Disabilities Act, under the employment provisions of that act, you are required to make a reasonable accommodation for someone that has a qualifying medical condition that makes it risky or dangerous for them to get a COVID vaccine. And then under Title VII of the Civil Rights Act, you have to make a reasonable accommodation for someone who has a sincerely held religious belief that makes them unable or unwilling to get a COVID vaccine. So if either of those 2 things, and I'll talk about both because they're really tricky and difficult to deal with, especially the latter, and I'm dealing with a lot of these requests for reasonable accommodations. You have to make reasonable accommodations in both of those cases. And the basic standard here is the same, which is that you have to make a reasonable accommodation to accommodate that employee, so long as the accommodation does not impose an undue burden on the employer. And so long as, even with that reasonable accommodation, the employee is still able to perform the essential functions of his or her job. So those are the 2 requirements that have been in place. Technically, they're a little bit different between the Civil Rights Act and the ADA, but they're largely the same. Just keep those 2 things in mind. So for instance, if someone's job, you know, going back to the person who delivers the mail or the receptionist at the front desk, you know, if they say, I have this qualifying medical condition that makes it dangerous for me to get a vaccine, here's my doctor's note explaining this, it passes the smell test. Although I will say and I've been down this path with a number of employers in recent months, they're right now, the experts, so to speak, can't point to many medical conditions that make it risky for someone to get a vaccine. There are some, like people who can go into anaphylactic shock from getting certain types of vaccines, but there are actually very few medical conditions that so far, again, this is all evolving science, that so far have been proven to make it risky to get a vaccine. And under the ADA, there's decades of precedent under that law about reasonable accommodations for medical conditions that qualify under that law. You're allowed to ask for a doctor's note. You have to be really careful what questions that you ask, because you want to avoid asking questions about the specific underlying medical condition. But you're allowed to ask for proof and ask for further. Like we had one recently, the employee had a note from a nurse practitioner out in Orange County, which basically said, my patient can't get the vaccine because it would pose a risk of death to her. And that was all it said. It didn't say anything more. And so in talking to my client and figuring out what they want to do, one of the things they were contemplating is, and in some cases, the employer is saying, look, we're just going to make a reasonable accommodation. We're not going to push back on this. But in a situation like that, you are able to go back to that person and say, no, we need something more from your doctor or nurse practitioner explaining why your medical condition makes it dangerous for you to get a COVID vaccine. You're absolutely allowed to do that. On the sincerely held religious belief, it's a lot more difficult. These are some of the most difficult ones that we've dealt with. The EEOC, Equal Employment Opportunity Commission, has some very helpful guidance on their website, a whole series of FAQs about all these different COVID-related employment and workforce issues. And they go into some really helpful detail about the kind of reasonable accommodations you have to make for these two, for both of these situations. They have guidance under the ADA and under Title VII of the Civil Rights Act. If you're dealing with these issues at all, if you have a vaccine mandate, I would strongly encourage you to go to their site and just Google it. It'll come up right away, and look at those FAQs. There's a lot of helpful information there. On the sincerely held religious belief, though, you are not allowed to ask them to get like a note from their priest or their rabbi. It's nothing like that. It doesn't even have to be an organized religion. It just has to be a sincerely held religious belief. We have seen a number of employees who have asked for a reasonable accommodation because of their sincerely held religious belief, and then they send essentially a form email or letter. We've seen a lot of them are very similar because I think they come off of certain conservative kind of right-leaning websites that talk about basically how the vaccines were developed with originally from fetal tissue and how that's contrary to their religious beliefs, and therefore they're not going to get vaccinated. It's a really tricky issue because apparently so many other commonly used medications like Advil and Tylenol were all developed the same way. So we have some employers saying, well, can we ask the employee if they're not going to take a COVID vaccine for that reason because of their religious beliefs, do they also, will they also attest that they don't take Advil, Tylenol, Benadryl, these other drugs that were developed in the same way? It gets really, really tricky, but that's the law and you have to comply with it. Now let's talk about, all right, let's say it passes the smell test. And you believe someone does have a truly qualifying medical condition under the ADA or sincerely held religious belief under Title VII of the Civil Rights Act. And you realize, okay, we have to make a reasonable accommodation. So what are the main reasonable accommodations that employers are making? Well, the two primary ones that we're seeing are A, remote work. Again, as long as it doesn't pose an undue burden and enables them to still perform the essential functions of the job. So if the job lends itself to it, remote work can work. We had one recently, though, where the smaller employer person was a meeting planner, and part of the essential function of the job is to go on site visits for site selection for events and to go and staff in-person meetings, of which the nonprofit was planning on having a bunch in 2022. And this person just wanted to be able to work completely remotely and not be vaccinated. Well, that doesn't pass the test of the employee being able to perform the essential functions of the job, even with the accommodation. So that wouldn't work. So the other alternative, and sometimes it's a combination of these two, is test and mask. So even if you have a vaccine only requirement, and that it's just vaccine only, you still have to make reasonable accommodations in these two cases. But the reasonable accommodation could be you have to show a negative COVID test within 48 hours, PCR if you want to, every time you're coming into the office and right before work travel. And you have to wear a mask and socially distance the whole time. So those are the two reasonable accommodations. Theoretically, there could be others. I don't know what they are. These are the two that everyone seems to be dealing with and talking about. But an important point to note, it's not up to the employee to determine what the reasonable accommodation is. It's up, the employer gets to decide. Has to be a reasonable accommodation. Again, doesn't pose an undue burden and still allows the employee to perform the essential functions of the job, but the employee doesn't get to decide. It's up to the employer to decide. So if the employer says, no, we're not having anyone do full-time remote work, you're going to need to be in the office 5 days a week, 3 days a week, whatever it is, and you're going to have to submit to a COVID test every week is what most seem to be doing. You could require it every day if you wanted to. In most states, you don't have to pay for the cost of that either as an employer. You can do that and require them to wear a mask. I've had some people say, well, forget about like a place like DC, which has an indoor mask mandate for now. But in a lot of other states and cities and counties, there is no indoor mask mandate. So assuming there's no indoor mask mandate, I've had some employers ask me, well, is it, how is it if most people who are fully vaccinated don't have to wear a mask in the office, but, Jane Doe, who's not vaccinated, is going to wear a mask, isn't everyone going to know that that person is, not vaccinated and essentially have a scarlet letter, I guess, across their face, figuratively, or literally. And, isn't that discriminatory? Isn't that a problem? And the short answer is no, you can do that. That is acceptable. I've advised employers to couple it with reminders about anti-harassment, anti-bullying, other things like that. You certainly don't want that person to become the stepchild in the office, that everyone is some people might stay away from that person, but, and that's okay. But if you, as an employer, allow a hostile work environment to occur and you don't do anything about it, you can then create a new liability for yourself as an employer. So it's something to keep in mind and be mindful about and remind people about that. But if you want to do that as your reasonable accommodation, you can certainly do that. Anyone have any questions on any of that?
Jeff, I'd love if we have time, and I'm looking, we have about 10, 12 minutes left. I'd love to open up and give people the opportunity to share perhaps some of either other questions for one another, with you here acting as a little bit of a, you can wave a red flag if there's something coming up that you'd suggest against, and to allow some time for anyone to share ideas, either that they've already done or that they would like to do in return to office, so accommodations, enticements, if that's the right word, or flip that, what you're doing to make it easier for people to work remotely more on a more permanent or consistent basis. So, and Melinda, I see you have a question too, so let's jump to you.
Yes. Hi, Jeff, and hi, nonprofit leaders. Jeff, you're amazing. So my two questions go off of what you just were saying about, the indoor mask mandate that you all have in DC. We have the indoor mask mandate here in California, and this could be applicable to others because it could occur in your state. How does that work with an employer when your employees are sitting at cubicles? Do they have to actually wear a mask while working in their cubicle? And then number two, when you were answering the question for the person from the YMCA about receiving federal funds, can you kind of share anything for our agency specifically and others that get federal funds? Any extra thing we need to be aware of? Thank you.
Sure. Good to hear your voice, Melinda. So first off, I'll do your latter one first. On the federal funds, I don't believe, and I don't stay up on all the various court decisions every day, but I don't believe right now that recipients of federal funds are required to impose a vaccine mandate on their workforces. Again, I could be mistaken about that, but I don't believe that's the case at the moment. All of this is all subject to change. On the mask mandate, you have to look to the laws or the executive orders themselves, because they're very specific in how they're written. So in DC, if I recall, the indoor mask mandate, the only exceptions are when you're actively eating or drinking, or if you're in a closed office, like a private office, within your workplace. Those are the only times when you're indoors where you don't have to have a mask. And as any of you who've been out to a restaurant in DC or California recently have seen, pretty much what that means is you have to wear a mask when you're coming into the restaurant, when you're going to the bathroom, when you're leaving the restaurant, but otherwise when you're sitting at your table or sitting at the bar, you don't have to have a mask on. That's effectively how it's been interpreted and applied in DC, California, and many other places as well. But you have to look to the specific rules. Like in DC, there would be no exception for someone who is in a cubicle, even if the cubicle has, like you've probably seen, plexiglass dividers that have been put up by some employers, but it doesn't completely close it off. There would be no exception in DC from the mask mandate for that situation, except when someone's actively eating or drinking. It's part of the reason why in places that still have an indoor mask mandate, those tend to be places where employers are not requiring their employees to be back in the office on a regular basis, because obviously, it would be impractical. And I can tell you from a practical perspective, I see it sometimes when I'm on Zoom calls with clients where some of the senior executives are in the office and they're not, some of them are together in the same room and they're not wearing masks, but they're also fully vaccinated and they feel more comfortable in that regard. So it's not like you're going to have some mask police coming through your office and enforcing it. But as an employer, you certainly have to have rules that apply to everyone. And, at least under the DC mandate, there would be no exception for when you're in your own cubicle, as opposed to when you're in your own private office.
Thank you.
Sure. One other point I wanted to make, it's not in the employment setting, but it's an issue that we're dealing with a lot these days. In the conference, meeting, and event setting, there are a lot of nonprofits that are imposing vaccination requirements for their in-person conferences, meeting, and events. In fact, again, varies depending on geography, nature of the industry or profession that the organization might represent, if it's a trade or professional association, things like that. But for those that do have a vaccine mandate, again, you have that same issue of, is it vaccine for everyone, fully vaccinated, or is it vaccine or test and mask requirement? You could do either, and we're seeing both. But for those that have, and if you have either, then it kind of makes the reasonable accommodation issue a moot point, because someone who can't get vaccinated, they can just do the test and mask option. But for those that have vaccine only, Title III, a different provision of the Americans with Disabilities Act, does apply to places of public accommodation, which include hotels, convention centers, restaurants, etc. And because of that, you do have to make a reasonable accommodation in the conference and meeting setting for those that have a qualifying medical condition that makes it risky for them to get a vaccine. And the same analysis I just talked through a few minutes ago in the workplace setting. And again, that reasonable accommodation in the conference setting, the two that we're seeing are A, test and mask, or two, having some sort of a virtual element where people can participate in the conference or meeting virtually or get access to recordings of the sessions later, that sort of thing. And that's probably, I say probably because none of this has been tested in litigation yet, but that's probably going to be considered a reasonable accommodation. But an important thing to note is that Title VII of the Civil Rights Act does not apply in the conference setting. It applies to staff. So certainly to your own staff, it might be staffing a conference, it applies. But Title VII only applies in certain contexts, like the workplace, higher education, other things like that, where they receive federal funds, but not in general to conferences or meetings. So you do not have to make a reasonable accommodation for someone who says, I can't get vaccinated because of my sincerely held religious belief. It's an important note because A, these are some of the more difficult accommodation requests to deal with. And frankly, we're seeing some that, at least in my judgment, some of the ones I've seen don't pass the smell test. It makes it a lot more difficult to deal with. And B, many nonprofits they're just assuming that because you have to make these two reasonable accommodations in the workplace, that you must have to make these two reasonable accommodations in a conference setting. And so they're allowing it, for both. But you don't have to do that. You certainly can if you want to. And for some nonprofits, it's important to them, for their culture, their whatever the kind of the underlying ideology of the organization, that it might be important for them to provide a reasonable accommodation for those with sincerely held religious beliefs. That's absolutely fine. I'm just saying from a legal perspective, you don't have to if you don't want to.
I do have a quick question on events, if we can follow up on this just a second. So appreciating that from the employers or the presenter of the events perspective, what about either checking them, like we're gonna have to set up a process of registration then to check a vaccine or check for a test. And are there any missteps? And that we've advertised that everybody's vaccinated, are we under any liability in those situations that we've promised that to our attendees if someone were to slip through that's not vaccinated, for example?
Yeah, so it's a great question. And it's an issue that so many organizations are dealing with. It's even, I was out at a restaurant last night in DC, and DC now has a vaccine mandate for going to restaurants. And had never seen it before, but there was like a line all the way, you know, from the front desk all the way out the door of people waiting to get in because, you know, the person at the front desk had to check, you know, vaccine cards and IDs to go along with it.
Yeah, we have that in New York City. I've been in that line.
Yeah, it takes time, and it's the same thing at conferences. So look, on the liability issue, as long as you're not negligent in what you're doing, it's not like a strict liability thing where if someone slips through and they're not vaccinated and they spread COVID and, you know, someone makes a claim, they would have to claim that you were negligent in how. It's not like strict liability means you're automatically liable. It's not a strict liability standard. It's a negligence standard. And so long as you're going through the right and proper protocols and whatnot, you're not going to be held liable for that. I wouldn't worry about that. Do your best. But I will say that one of the things that some organizations are doing are encouraging attendees to sign up for one of these apps where you can upload your information to that app. I think I've done two of them. One is through Clear, the airport security company. They have something called Health Pass. And then there's another one that I saw recently that I signed up for. Of course, in New York, where you are, Abby, you have that Excelsior Health Pass. And I think a couple other states are contemplating their own kind of version of that. If you encourage people to do that, it can help streamline the process because, you know, someone just pulls up the Clear app and it shows a QR code and it shows your picture. So it kind of obviates the need to check an ID along with a vaccination card, and you don't have to sit there and read.
Do you want, while I listen to this, you want to make a copy of Teresa's?
Can we ask you to mute, everybody mute, please, other than Jeff? Thank you.
It just makes it a lot more of a streamlined process. You can also pay companies like Clear as the conference organizer to basically, from what I understand, I've not seen it in person. I think you pay a certain dollar amount per head for people, and then they give you like access to a scanner where you can kind of scan people's QR codes on the Clear app and things like that. Look, even when you do that, you know, the ones I've seen, I was at a American Society of Association Executives event here in DC a few months ago, and they encouraged people to use one of two apps to do that, to kind of streamline the process. But then they also allowed, you know, a photo of the vaccine card and an ID at the same time. But the more you can get people to do that, the more it's going to streamline the process. But it's something you're going to have to build into it. And yes, if you're going to have a vaccine requirement, you are going to have to do that.
Thank you. It's helpful.
Yeah, thanks, Shannon. Shannon posted, we have a lot of resources on our firm's website. The link that you just posted is where we have all of our publications, both articles and PowerPoint presentations. And there are a number that we've written on these specific issues. There's one all about workplace, COVID-related workplace issues. Most of these were written at least a few months ago, but they're still largely current. And they contain links, that article, to the EEOC guidance. There's a number that I've written on meeting and conference related legal issues. Feel free to take a look at those. And then there's another link on there to all of our recorded webinars. I have never given so many webinars as I've done in the last 2 years. You know, the remote work and Zoom has made that a lot easier to do. And I've done probably 150 of them in the last 2 years. And a lot of those are recorded and available on our site on a whole, much more than just the COVID related legal issues, all different sorts of nonprofit legal and tax issues. So feel free to take a look at those if you're interested in getting more information on any of those topics.